All rise. The Honorable, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon and welcome to our beautiful courtroom here at the North Carolina Court of Appeals. I'm Judge Valerie Zachary. To my right is Judge Allegra Collins. To my left is Judge Jeff Carpenter. To your right is our Deputy Clerk Roderick McFarland and Officer Tom Salute. This afternoon we have the case of McGeehee versus Farber. I hope I said that right. How have y'all divided your argument time?
I'm Eric Zimmerman for the appellants, and I'll be speaking first and reserving 5 minutes for it.
Okay. Well, it looked like that there were several attorneys for McGeehee.
I'll be speaking for all of you.
Okay, all right. That's what I wanted to know. Okay, you may approach the lectern.
Thank you, Your Honor. And as I mentioned, I'm Eric Zimmerman with Robinson Bradshaw for all of the appellants. I'm joined at the council table by my colleague, Clara Neiman. And as I mentioned, I'll try to reserve 5 minutes for rebuttal, if I may. This appeal involves 3 statutes, all of which share a common goal: to help patients receive safe and effective medical care. The 3 statutes at issue are the Federal Safety Act, North Carolina Statute on Medical Review Committees, and North Carolina Statute on the doctor-patient privilege. Each of these statutes shields certain discussions from discovery. The first 2 statutes, the Safety Act and the Medical Review Statute, shield discussions about patient safety issues. The third statute shields discussions between doctors and their patients about medical information. The reason why these statutes shield those discussions from discovery is to encourage candidness in those discussions, to encourage frank, honest discussions of patient safety and medical treatment. And that ultimately benefits patients because those kinds of candid discussions are crucial to safe and effective healthcare. Now, the trial court in this case violated all 3 of these statutes. The court violated the Safety Act by adding a requirement to the statute that the statute does not contain a sole purpose rule that I'll discuss in more detail in a moment. The court violated the Medical Review Statute by ordering UNC Health doctors to testify about their knowledge of incidents involving Dr. Farber without making any exception for knowledge that those doctors gained through medical review proceedings. Finally, the court violated the doctor-patient privilege by ordering UNC Health to produce medical information of patients who are not parties to this case and who have not consented to having their medical information revealed. By violating all 3 of these statutory privileges, the trial court chilled the candid discussions that these statutes try to promote. And the ultimate harm from that chilling will fall on patients, because that chilling effect will make it harder to have the candid discussions that are important to safe and effective medical care. And so for those reasons, we ask this court to reverse the decision of the trial court.
Just to begin with, I'll make sure that it is your burden, correct, to show that these things were privileged?
Yes, that's correct, Your Honor. We agree it's our burden, and we believe we've met that burden here. Before I turn to the legal issues in the case, I want to just briefly clarify what is at stake in the appeal, what the scope of the appeal really is. Ms. McGeehee, in her brief, said that in response to her subpoenas, we are refusing to produce anything at all, and that's not the case. So we have agreed to produce certain non-privileged documents in response to the subpoenas. The doctors who have been subpoenaed will testify. We're not trying to prevent the depositions from going forward at all. And by the way, earlier in the case, we made a large production of documents to Ms. McGeehee. She has Mr. McGeehee's medical records, and the defendants in the case, the 3 defendant doctors, have already been deposed. So this is not a situation where we are trying to avoid any discovery at all. What is at issue is a narrow set of privileged materials and testimony. We're dealing with just 2 privileged documents and just 1 category of privileged testimony. So with that scope in mind, I'll turn to the first statute here, which is the Federal Safety Act. The Federal Safety Act creates a privilege for patient safety work product. That is a term that the statute defines, and it gives multiple definitions for the term patient safety work product, and the statute says that patient safety work product is privileged and confidential. It's not subject to discovery, can't be subpoenaed, it's fully protected. Why does the statute do that? The statute does that to encourage healthcare providers to have frank, honest discussions about patient safety. So the concern that motivated this statute, which was enacted in 2005 by Congress, was that healthcare providers didn't have the proper incentives to have discussions about medical errors that were occurring. There had been a study in the 1990s saying that tens of thousands of patients died each year from medical errors. But those medical errors weren't being properly discussed because providers were concerned that if they had discussions about these medical errors, those discussions would then come back to be used against them in litigation. So what Congress did in the Safety Act was try to encourage those discussions of patient safety and medical errors by creating a privilege for those discussions. And the statute creates a privilege for data, reports, documents, discussions that are prepared and for the purpose of being reported to.
But it says for reporting, right? I mean, are we really talking about 2 words in the statute, for reporting, and whether that is solely for reporting or for reporting and anything else? I mean, doesn't that really get to what the issue is here?
Absolutely, that's the key issue.
Isn't it ambiguous, though? I mean, can see it both ways. If I say pizza's for dinner, that's it. You don't have any other choice. Or pizza's for dinner, but I don't want pizza. All right, well, we also got hamburgers. It seems like it's ambiguous to me.
We think it's clear, Your Honor. So, I think, for example, if I say I'm going to buy my daughter a dress for a party, that doesn't mean she can only wear it at the party. She can wear it somewhere else. But I'll take, even if the statute is ambiguous.
Okay, that's where I want to go. Even if it's ambiguous, then how do we decide?
So there are multiple reasons why the word "for" should be understood to refer to a purpose and not a sole purpose. So number one is when Congress wants to refer to a sole purpose, it knows how to do that, and it uses phrases like solely for or only for. And so we searched Title 42 of the United States Code, which is the title in which the Safety Act appears. We found over 400 examples of the phrases solely for or only for. And so what all of those hundreds of examples show is that when Congress is trying to impose a sole purpose requirement, it uses the word sole or only or those types of phrases. And so in this statute, when it just said for, without including the word sole or only or any kind of qualifier like that, that tells you that it meant for that reason among others.
I noticed in your brief you're relying on the Baycare case from the 11th Circuit. Isn't that, from the briefs it appears that that's an outlier. Do you consider it an outlier?
No, not at all, Your Honor. That is the only federal court of appeals that has addressed whether there's a sole purpose requirement in the statute, and the 11th Circuit rejected that rule. So that, we don't think it's an outlier at all. In fact, it's the only federal appellate court that has addressed the issue, and it's come out in our favor. Now, Ms. McGeehee points to district court decisions in other jurisdictions. Only one of those decisions, which is an unpublished district court decision from a federal court, actually squarely adopts a sole purpose rule. As we discussed in our reply brief, most of the other cases that she cites in her brief are actually dealing with a separate issue about whether healthcare providers can use patient safety work product to meet external obligations that are imposed on them by federal law or state law. So for example, federal law and state law impose many obligations on healthcare providers to keep certain records. So for example, federal law, CMS requires hospitals to keep records on adverse incidents. They have to, if they have an adverse incident at the hospital, they have to make a record of that. What the Federal Safety Act does not do is make those types of documents that are used for external obligations privileged. Providers have an obligation under federal law to make those records. They can't then turn around and say, oh, the records are privileged because they're under the Safety Act. The Safety Act excludes those documents that are created to meet external obligations. That's what the cases that Ms. McGeehee discusses in her brief say. Here, in contrast, the trial court held that the document that we're talking about, the SAFE report in this case, fails to satisfy a sole purpose requirement because it is used for other internal purposes within UNC Health. So we're not dealing with a document that's used to meet external record keeping or reporting obligations. We're dealing with a document that UNC both sends to its patient safety organization and uses within UNC Health to try to improve patient safety. So it's trying to use the document.
I'm sorry, is it somehow, does it maintain its privilege throughout the use of all those different internal uses? You know, it seems like if you create it for use with the safety organization, but then you use it in other places, at some point it loses that privilege, no?
No, it doesn't. As long as the document stays within UNC Health and stays within its patient safety evaluation system, which is what's going on here.
But if it goes outside of its patient safety evaluation system, I thought that's what I understood you were saying. It's using it for other things within the hospital, but not within that safety system.
It is staying in the system, and within that system it's being used for other patient safety purposes to make improvements in the processes that the hospital uses to avoid other kinds of medical errors. And those kinds of internal uses where it's still, the report stays in the system. The report never leaves that system and goes elsewhere.
Can you explain that really technically to me then? You're telling me it doesn't leave the system. What does that mean? Does that mean it's not printed off and put on somebody's desk, or does that mean that somebody doesn't open it up on their computer screen? What does it mean to leave the system?
My understanding is what you said, Your Honor. So the SAFE system is a computer program that UNC Health employees can access from their computers. So they can go into the system and access the SAFE report there. They don't then, my understanding is they don't then transport it into other files, other systems on their computers. It stays there, but within that, they can pull it up and look at it and say, oh, okay, I see that this happened in this particular case. Let's use that to inform our thinking on how we can improve what we do at the hospital to avoid any kind of medical errors in the future.
It just seems like a fine line between saying it stays in the system when you're pulling it up, even on your computer, and maybe taking that information and using it to make another report, for example. It's hard sort of conceptually to understand how it stays somewhere.
Well, let me also tell you this, Your Honor. I don't think that fine line actually makes the difference in this case, and this is another point I want to make, which is that the statute itself says that patient safety work product can be used for things other than reporting to a patient safety organization, and the information still maintains its privilege. And the statute says it actually can be taken outside the system and other things can be done with it. And it still maintains its privilege. And that is in section 299B-22, subsection C and D. This is at pages 6 to 8 of the appendix to our brief. And what 22C and D say is that healthcare providers can do lots of things with patient safety work product other than just reporting it to a patient safety organization, and the information still stays privileged. So, for example, C2 says patient safety work product can be disclosed to carry out patient safety activities. It says that patient safety work product can be disclosed to grantees, to contractors, or to other entities carrying out research, evaluation, or demonstration projects. It says the information can be disclosed to the FDA. It says the information can be disclosed to an accrediting body.
Does it say it can be disclosed to all these places and maintain its privilege?
Yes, that's exactly what the statute says. So in D, it says all of those disclosures, it says patient safety work product that is disclosed in those ways I just said shall continue to be privileged and confidential.
And the federal government requires you to prepare this report, correct?
No, Your Honor.
It's a federal SAFE Act.
It's a voluntary system, and so what the federal government has done in this statute has said, if you choose to create this report, we will make it privileged. So it's creating an incentive for healthcare providers to create these reports. And if they do, the material will then be privileged. So just to close out the point I was making to you, Judge Collins, all those examples that I just read say that information actually can leave the system, however you define it technologically, in lots of different ways without the privilege disappearing. And so that part of the statute itself defeats a sole purpose rule, because under a sole purpose rule, under the rule that the trial court adopted, the only thing that can be done with patient safety work product is to send it to the patient safety organization. What that part of the statute says is that that's not right. Lots of other things can be done with patient safety work product other than sending it to a patient safety organization. And so that context in the statute, reading the whole statute in harmony, shows that the definition of patient safety work product can't include a sole purpose rule. The one other thing I wanted to point out from the record, we didn't address this in our briefs, but another point that shows the absence of a sole purpose rule, or supports our reading, is in the record at page 184 is UNC Health's contract with its patient safety organization. And as far as I can tell, that's a standard contract that the patient safety organization uses for all of its providers that it works with. And that contract as well says that UNC can use patient safety work product for other internal purposes and to do patient safety activities. So this isn't just an interpretation that UNC Health is coming up with. This seems to be the kind of the industry practice is to understand the statute.
If they're using it for a purpose other than you've referred to it as a report, and it's actually the work product. It's much broader than just a report. It's more than just a few pages. It's all the stuff that goes into the formulation of the report as well. If it's used for purposes not within that, like for internal, how's the privilege maintained? Is that left to the hospital to maintain the privilege outside of the production? How does that work?
I believe so, Your Honor, yes. So I think that UNC Health maintains, or the provider maintains the privilege by only using it for patient safety related purposes and not making disclosures that, other than the ones that I mentioned that the statute allows.
In light of that, how does it continue to qualify as, it's like attorney work product. If the attorney produces work product in the litigation or the development litigation strategy, whatever, all that's privileged. We're talking about work product privilege for safety assessment here under the federal statute. If it's used for the same information is used for purposes not within the product, I'm trying to comprehend how it maintains the privilege even though it's being used outside of what the intended privilege is, which appears to be the case here.
Well,
can you not use it contrary to the statute and basically dilute the privilege is the question.
Well, Your Honor, we would say that the uses here reinforce the privilege and advance the objectives of the statute. So I guess I'd make a couple points in response to your question.
Advance the objectives of the statute for whom, though? That's the question. Is it the federal government? It's designed for the federal government to get the stuff. If they're using it internally, that's That's a different party for a different purpose.
Well, it's not designed to go to the federal government, Your Honor. So for a report or for the information to qualify under this first definition of patient safety work product, it needs to be prepared for reporting to a patient safety organization, which is a private organization.
Thank you for correcting me on that. Patient safety organization is, when I said federal government, I was thinking patient safety organization.
Okay, gotcha. What the statute says is that as long as that is a purpose of preparing the report, and as long as you send it to the patient safety organization, then that information is privileged. And then the question here is, and I think you're getting at this, does it somehow destroy the privilege to go on and use the information for other purposes? Nothing in the statute says it does, and in fact, the parts of 22C and D that I mentioned show that those other kinds of uses do not destroy the privilege, because the statute says you can do lots of other things with the information other than send it to a patient safety organization, and the privilege is maintained.
It seems that if we were to apply the law the way that you are asking us to, it creates a large bucket where information can be dumped and shielded from view outside of the confines of the healthcare structure. Certainly one could see how that could be used as a shield and potentially a sword, depending on which way you wanted to use it. And, with the broad, it's not just the report, it's all the work product and data and statements and all the things that go into the formulation of the report. It would seem that it would incentivize the over placement of information into that protective bucket rather than just the stuff that was needed to produce the report. So that's not really a question, it's more of a thought.
Well, yeah. Congress...
I was going to say, it's a really good question. How can this not be used to shield information that should be out there? But if you use it for reporting and send it to, the organization, then it's shielded.
Well, Congress addressed that concern in the clarification that's in the statute, which comes right after the definition of patient safety work product. And that clarification says, for example, that a patient's original medical records are not patient safety work product. So a healthcare provider can't take medical records, put them in the system, and then say that they are privileged. It says that extends to any other original patient or provider record. It then says information. And then later down on that page, it says that what's that saying is that that's the information that could be used for reporting to the federal government, reporting to the state government under external laws, or for record-keeping obligations that are imposed by federal law or state law. So what that clarification is saying is that if you have a document that some other source of law requires you to create, you can't then just stick that in the patient safety evaluation system and claim it's privileged. It doesn't work. So this is not a place where you can hide information that would otherwise be created or that you otherwise need to create under federal or state or local law. What the statute here is doing is trying to encourage the creation of information that otherwise just wouldn't exist. So that's what Congress was trying to address. It was saying at the time the statute was enacted, this information just wasn't being created. This is information that would be helpful in improving patient safety, but it wasn't being created at all for fear that it would then be used against the provider in litigation. So when you look at it from the perspective of a plaintiff in a case, for example, they are no worse off just because this information is shielded from discovery, because if not for the statute, this information wouldn't exist at all and it wouldn't be available to the plaintiff anyway. So the plaintiff in a case who's trying to get this information is no worse off by virtue of the privilege. Who's better off, in Congress's view, are the patients who are going to benefit from the creation of this information within the system and the use of it to improve patient outcomes, reduce risk, and lead to safer patient care.
Can we jump to the Medical Review Committee?
Certainly.
So my question is about the evidentiary support in Dr. Zavar's affidavit. He's aware of no conversations outside peer review. How does that essentially prove your burden that there might be some privileged information here?
A couple points on that, Your Honor. So in context, what I understand Dr. Zvar to be saying there is that there are at least some discussions of Dr. Farber that happened within medical review committees. So he lays out the various kinds of medical review committees that UNC Health has, including, he specifically calls out the medical review committee of the Department of Surgery, which is Dr. Farber's department, and then he made the statement that Your Honor said. So in context, I take that to mean he's saying he's aware of at least some discussions of Dr. Farber that happened within medical review committees. That's the evidentiary showing that's required by the statute. The second point here is just another contextual point just about how all this came up, is that basically we went to the trial court and seeking guidance about kind of the ground rules for these depositions and just trying to get clarity that if during the depositions questions were asked that called for information from medical review committees, we could object at that time and raise the medical review privilege. What then happened is the trial court issued an overbroad ruling that bars us from even making that objection in any way if any questions are asked that call for medical review proceedings to be disclosed. And so really all we're asking for here is to cut back on that overbroad ruling and just make clear that if specific questions are asked in the depositions that call for answers that would reveal the privileged discussions of medical review committees, we can object at that time.
So is it your contention then that anything presented during the committee proceedings is immune from discovery?
No, Your Honor. There is an exception for information that's available from original sources. So for example, if materials are presented to the committee, but if a party can get those materials from elsewhere, they can get the materials from that other source as opposed to needing to go through the committee. So the problem here is that the doctors who have been subpoenaed here are not original sources of the information. We're talking about information that they learned solely through the medical review proceedings. And what we're saying is that even if information might be available from some other person, some other employee at UNC Health, maybe if there's some document out there, the place to get that information is from that original source, not from the member of the medical review committee.
How would plaintiffs determine who that source would be?
Well, yeah, that's a good question. I mean, they need to find some way to get there other than going through the medical review committee. So because otherwise, if they could go through the medical review committee to find out who the original sources are, that would really defeat the whole purpose of the medical review committee, which is to keep the things that happen within the committee private and shielded from discovery. And that's shown by, I'll just say, it's shown by the Shelton case and the Armstrong v. Barnes case. Both of those decisions addressed this otherwise available information, and what they held is that you can seek the information from the original source. They didn't hold what I understand Ms. McGeehee to be saying here, which is that just because there is an original source out there somewhere, you can go through the committee to get that information.
Okay. I just wanted to let you know you're into your rebuttal time.
Thank you, Your Honor. I'll wrap up there. Thanks very much.
Thank you.
Good afternoon, Your Honors. Bailey Melvin for the McGeehees. I want to take just a couple minutes to, I normally talk to juries, and I try to be kind of straight and to the point with juries, so I'll try to be kind of brief and to the point with you as well, but I want to take a couple minutes to make sure you understand sort of why we have asked for this discovery and the importance of it in the context of this case. Mr. McGeehee had an aortic dissection, what's called a type A dissection, which I think at the end of this case, when we get to trial, everybody will agree needs surgery. And he was transferred to UNC with an outside hospital CT scan and then an inside UNC CT scan that proved that this was a type A dissection. The emergency department contacted Dr. Farber because according to UNC policy, he's the one, his department is the one that's supposed to admit this type of patient. Dr. Farber refused to do so. In fact, you've probably seen in the record where there was a point where he hung up on the referral coordinator during the course of their conversation. Because of his refusal to admit Mr. McGeehee, the emergency department doctors at 5:30 on a Sunday morning had to go up the chain of command to both the head of the Department of Surgery and the head of internal medicine to get Mr. McGeehee admitted to the hospital. And we think this set up really kind of a turf battle between these doctors that led to Mr. McGeehee. Nobody wanted to treat him. Nobody wanted to do surgery. They eventually sent him home. And within 24 hours, his dissection burst and he died. And so that was why we started looking into this situation with Dr. Farber.
Do you have any idea why they wouldn't want to operate on Dr. McGeehee? I mean, Mr. McGeehee?
You know, what is apparent, at least to me, Your Honor, from the depositions in this case, is that it just became a turf battle and a dispute. The doctors were mad at each other because Dr. Tessman was mad that his department had to take the patient. Dr. Farber was mad that these other doctors had gotten involved, that they'd gone up the chain of command, and nobody wanted to pay attention to the CT scan. Dr. Farber didn't even look at the CT scan on this patient that showed that he had a type A dissection. So I think it's the personalities of medicine. You know, these people aren't robots. I think they were mad at each other, and nobody wanted to take care of Mr. McGeehee.
Can I ask you something about the Patient Safety Act? So if we determine that the sole purpose doctrine is not applicable here, if we went the route of the 11th Circuit, do you have other arguments as to why that information?
Yes, Your Honor. I don't think that the court has. I do believe that the sole purpose doctrine is the right doctrine in this case. I think that's what most of the courts that have looked at this issue have adopted. I don't think that you have to get at that because UNC has admitted that they use this for lots of other purposes. What they haven't done is detail for you, which they could have done in affidavits, what those purposes are. It's just sort of left to the imagination what all they are using this for. And so they haven't, you know, the SAFE report, if you look at the policy itself produced in this case, it's an incident report. It's what it's commonly known as, which anytime something that shouldn't happen in a hospital happens, somebody's required to report it and put an incident report. And it was interesting. Counsel said that this info, this SAFE report wouldn't exist at all if not for the federal statute, and I don't think that that's correct. I think the hospital policy details that they're using it, the main purpose of the SAFE Act, or this incident report policy, is for internal quality improvement, not for reporting to the federal government.
Are they using the SAFE Act in ways that are not enumerated in the statute?
Yes, Your Honor. I mean, they have admitted that at the trial court and in their brief that they're using it for other purposes. And if it was purposes that were within the statute, they have the burden in this case of proving that they meet all these privileges. And there's no affidavit that details how they're using it. And so by definition, they haven't met the burden of proving that they've stayed within the statute, it seems to me, Your Honor.
Do you know what ways they're using it that aren't enumerated in the statute?
No, because they have not detailed, you know, what those are. They just said that they use it for multiple purposes. The policy itself says they use it for internal quality improvement. Now, the North Carolina courts have decided a long time ago, I think it's the Cook versus Wake County case, that just incident reports that are prepared in the regular course of business like this one don't qualify as peer review. There's no evidence that this report made its way to a medical review committee. There's no affidavit from anybody saying that either that was why it was repaired or that it was even reviewed by any medical review committee in this case. So, you know, I think that was their burden to have more and better affidavits. The only affidavit they submitted was from Dr. I think it's Zavar is how he pronounces his name. And, you know, it's obvious from the other documents in this case that Dr. Zavar's affidavit is incorrect when he says that Dr. Farber's conduct has never been discussed out, or to his knowledge, outside of a medical review committee. We know from other documents produced that, for instance, Dr. Farber was disciplined for his conduct with other staff, and that was decided by Human Resources. It didn't go before any kind of medical review committee. You know, they've produced what they call a spreadsheet of complaints against Dr. Farber by patients, by other, I assume by other physicians or nurses as well. They haven't detailed that those are privileged in any way. They say that these complaints are privileged pursuant to physician-patient privilege, but according to the documents in the case, they were produced to the Patient Relations Department, which is not a medical review committee. Again, there's just no evidence that any of these things were reviewed or submitted to a medical review committee.
Now, that spreadsheet had patient names in it. Did those patient names get redacted, or do they have to be redacted?
Yes, Your Honor. I mean, my understanding of Judge Locke's order is that he ordered all personal information to be redacted, and that was we agreed with that at the trial court level. Another interesting thing that the counsel said was that I wrote down was that he said that the subpoenaed doctors learned of the info about Dr. Farber solely through medical review committee proceedings, but there's just no evidence of that in this case that I'm aware of. They didn't have affidavits from these doctors saying the only thing I know about Dr. Farber's misconduct is through the medical review committee. I mean, a couple of the people we subpoenaed in this case were the doctors, the head of the Department of Internal Medicine, the head of the Department of Surgery, who were called that Sunday morning to, because Dr. Farber wouldn't admit this patient. So they obviously have, evidence about his conduct that's outside of a medical review committee. They have evidence from that phone call. So I'm not sure, again, that they've submitted the evidence that would be needed to claim these privileges, because I think, at least, my interpretation of how the Court of Appeals and Supreme Court has interpreted, for instance, the medical review privilege, is that it's there, and it's if you meet the standard of it, if you can prove, okay, this is truly medical review stuff, then you get the privilege. But if you don't carry your burden, if all you have is some kind of conclusory affidavit, then what the Hammond cases have said is that that's not good enough. This is an important and a big privilege that I don't want to say hides or covers up, but that's essentially what it does. It shields discovery that would otherwise be very relevant to a case, but we're only going to let you have that privilege if you truly meet it, if you prove that you meet it. And I just don't think Dr. Zavara's affidavit goes there, and I think there's enough that we know for a fact is wrong in Dr. Zavara's affidavit that I think it has to call into question, how much, I'm not accusing him of saying anything wrong, but how much he really dug in to what was going on with Dr. Farber before he signed that affidavit.
Can I ask you about this the spreadsheet of patient complaints, again, going back to the physician privilege? Whose privilege is that? Who has to assert that, and how do we deal with the fact that it's not the patients here who are asserting it?
Well, in our opinion, it is the patient's privilege, and the patient is not asserting it. But I don't think there's even any evidence that physicians were involved, that this is patient-physician discussions. It seems to me like what the evidence would show is that it's patient conversations with the Patient Relations Department, which is typically administrative personnel and not doctors. But again, if doctors were involved in that, it would have been fairly easy for UNC to file affidavits saying that. They haven't done that.
If a patient reveals to the patient relations staff something that would otherwise be privileged under the doctor-patient privilege, is that privilege gone at that point? Has the patient, him or herself, basically waive that by reporting it to the staff.
I've never thought of it that way, but I think that's probably true, Your Honor. It is that, because a physician, one, the patient's relaying it to a third party. I equate it to when, if I'm talking to a client and there's a third party in the room, then that third party can then be asked about what that conversation was about, because the privilege is waived sort of in that respect. So I think that's probably right, Your Honor. I want to get a little bit to the, we've talked about the spreadsheets of complaints. The incident report that was filed in this case, in addition to saying it's privileged by the Patient Safety and Quality Improvement Act, and I do think Your Honor is correct when you pointed out earlier. I do think the Baycare case, I always have trouble not calling that the Baywatch case. The Baycare case is one thing. I do think it's an outlier when you look at the other courts that have looked at it. In fact, I think it's the Kentucky and the Florida Court of Appeals that looked at this same statute, said that if the hospital even keeps a copy of it, that they've waived the privilege under the Patient Safety and Quality Improvement Act. But also, I think if you look at our brief, I think the Baycare case is talking sort of about a slightly different part of the statute than what we're talking about here, and it doesn't apply for those reasons. But they're also claiming that this incident report that was filed, it was filed before Mr. McGeehee even, the safe report, even before Mr. McGeehee even left the hospital. I think it was the day after he was admitted. They're also claiming that it falls under the peer review privilege. And again, I don't think there's any evidence that this report was ever submitted to a medical review committee, or was prepared, or even considered by a medical review committee in this case. So I just don't see how that privilege applies in this case. And it was interesting. The other thing is that they've seemed to set up that what they want the court to rule is not sole purpose on the Patient Quality Improvement Act, but they want to say a purpose. And it seems that that doesn't match up with what the majority of the courts that have looked at this issue have ruled. And also, if they just wanted to, if the Congress wanted it to just be any purpose, a purpose, you use it for everything else, I think they would have said so. I think the reasonable interpretation of the Patient Safety and Quality Improvement Act is that if not the sole purpose, it needs to be the main purpose. And that's not true in this case. At least there's no evidence it's true in this case.
Can you tell me why you think it's important that the incident report was submitted before he went home? What is the purpose of sort of highlighting that?
Because it shows, one, that it was not, they weren't worried necessarily about a claim, that this is, the incident report filed in the regular course of business. This isn't some investigation that was done after somebody died. This was, we don't know who filed the report, but it doesn't seem to be a pretty logical jump to think that there was somebody in the emergency room who was upset about all the hoops they had to jump through to get this patient admitted. Because, if they detail in the records how, everything they had to do to get the patient admitted, and you don't have to read too far between the lines to see how upset they were about what happened in this case, and how, they couldn't get the patient to a room and to the care that he needed. So I'm happy to answer any other questions that you have. I wish I could fill up all 30 of your minutes, But that's all I've got to say about it, but I'm happy.
It's not a challenge.
But I do have a question for you, or a few
Yes, sir.
questions for you before you sit down. So the order entered by Judge Locke, opposing counsel sort of framed it. Opposing counsel has stated that the standard of review is de novo
Yes, sir.
because we're interpreting a federal statute and how it applies. As I'm reading the order, certainly that aspect is there in regards to whether there's a sole purpose requirement, which the court interpreted it as it was a sole purpose requirement in order to qualify for the privilege. But there, if you read through the order, there are other things in here that where the court kind of says, you got to turn this stuff over, you got to turn this stuff over. So if we get past that de novo review in your favor, do we still need to look at the other stuff in your view?
I don't think so, Your Honor.
And if we do, what's the standard of review there?
You got me on that. I'm not positive what the standard of review is on that one. I think it's probably abuse of discretion on those issues that aren't de novo.
Well, the main thrust of this case is Judge Locke read into the statute a sole purpose requirement. And that's what your opposing counsel has taken issue with because those words don't appear in the statute.
I agree that that's a significant part.
And that's statutory interpretation. I think it sounds like you both agree that that's de novo review.
Correct, Your Honor.
And since you do, I think you're both right. But beyond that piece, there's other things in this order where the judge kind of goes through and says, you'll have to turn this over, you'll have to turn this over. That's why I asked the question, if we get past that initial question of law, do we still need to go through the abuse of, if it's abuse of discretion, on the remainder of the things?
Yes, Your Honor.
That's your answer?
I think it is I don't think it's a de novo review on those issues. Because I think most of them don't. There's no privileges that apply.
I want to ask a question about the medical review committees. From what I understand, on their side is saying that they simply want to be able to object when somebody's asked a question and that knowledge originated in the committee. Why is that not an okay order? Why do we have this blanket order that seems to go beyond that?
Well, I think the main reason is they didn't ask for that at the trial court. So I don't disagree with Your Honor. For instance, if there is one of these physicians or witnesses that did solely learn something in a medical review committee, if that's the only place they know about it, if there's no other, then that would be privileged. So I don't, their right to object to something that's solely, but I think they've got to, the witness has got to testify to that. That's the only place that they know about it. It's, because what we think happened, all these physicians were either involved in this case or involved in other complaints about Dr. Farber. And I think what we do have a right to know is, what they know about these issues with Dr. Farber that are outside of a medical review committee. And so the chairman of the Department of Surgery, I have trouble believing that the only place he's ever heard of a problem with Dr. Farber is at a medical review committee. Maybe that'll turn out to be the case, but I think we have the right to answer that, asking that question. But I do think that they can still object to that.
So I guess I feel like both sides are essentially agreeing on what the law is and agreeing that you can ask questions and agreeing that if it was only learned in a medical review committee that you could say, I can't answer that, that's privileged. So I'm just having trouble finding out where the disagreement is and how we would write an opinion to address it.
I think you could write it that way if they solely learned of issues with Dr. Farber only in a medical review committee hearing. then they wouldn't be required to testify about that.
It just seems like this is the law, and the parties agree.
I agree.
Mr. Melvin, let me ask you this highly technical legal question, operating in the world of hypotheticals. So had Judge Locke said, you know what, I'm not going to rule on this now. You guys take your deposition. You can tell your client, you can object, tell your client not to answer, and you bring your objections back and I'll rule on them before you move forward. That's not a blanket approach to things. Are we here today if that's the way Judge Locke undertook it, or are we only here because there was the blanket approach on the front end?
I think on the witness issue, I think, you know, the focus of the appeal is not just a witness issue, it's the incident report, the SAFE Act, these spreadsheet of complaints. On the witness issue, if he had ruled that, I don't think that we would have come up on that issue. I think we might have come up at a later time on that issue, but not now.
Yep. Thank you.
Thank you, Your Honors.
Thank you.
Thank you, Your Honors. So on the Medical Review Committee, it sounds like we now are in agreement. The problem is Judge Locke's order doesn't match up with the law. So Judge Locke said plaintiff can ask the doctors about their knowledge of any other incidents involving Dr. Farber where his care or his interactions with patient, staff, or employees may have been called into question, period. What he needed to do is then go on to say, unless the doctors gained that knowledge solely through a medical review committee. So we totally agree that the doctors can be asked about things that they learned from outside a committee. The problem is Judge Locke's order compels them to testify even if they learned about things solely through a medical review committee. So what we would urge the court to do in its opinion is to say Judge Locke erred by not including that exception for information learned solely through medical review committees, and he erred to that extent. On the Patient Safety Act, so first on Baycare, my colleague said that it was addressing a different part of the statute, and he said that in his brief too, that it was about patient safety analysis. First of all, that's not, Baycare didn't limit its analysis to that. It said over and over again, about 5 times, nothing in the Safety Act imposes a sole purpose rule. And in any event, even if we were talking about this other part of the statute about patient safety analysis, the SAFE report in this case is a patient safety analysis because it contains analysis of Mr. McGeehee's condition and treatment. And so if my colleague is saying there's no sole purpose rule for patient safety analysis, then we win under that argument because this is a patient safety analysis. On the point that the report was filed while Mr. McGeehee was still in the hospital, we've submitted the report in camera, so your honors can look at the report and see that it was updated after he left the hospital and discusses his death. So there's analysis of his death in the report that shows that this report is patient safety work product under the analysis definition, which my colleague says there's no sole purpose rule for even under Baycare.
So how would that work if you have a report that is not submitted, for example, and then it is updated and becomes submitted? Does that automatically make the original report that's now subsumed in the updated report privileged? Is that the argument?
I believe so. The report that's submitted, even if it's compiled over time, that's patient safety work product. And then what the analysis prong of the definition says is that as long as you have analysis going on in the patient safety evaluation system, that is protected. It doesn't even require submission to the patient safety organization. So if you have a report that has analysis in it and it's in the evaluation system, that's privileged under that definition in the statute. So we satisfy both. This was prepared for submitting, it was submitted, so it's a patient safety report, and it's analysis as opposed to just data or other things. And so it's privileged in that way as well. And I'll just say that page 205 of the record, that's where it describes what we do with the analysis, and that is within the statute because those are patient safety activities as defined in the statute. Thank you, Your Honors.
Do you have further questions?
I don't think so.
Further questions? Thank you very much. That concludes oral argument in this matter. I want to thank you both for your excellent arguments. We'll take this matter under advisement.
All rise. This session of the North Carolina Court of Appeals is now adjourned.